Hi there, I'm James Dafferty, and this is Coffee and a Case Note. So what do you lose if your solicitor's too slow? We're taking an adventure through an appeals decision today, guys, that hopefully is going to give you a bit of value. Right, 2006, we have a client who instructs his lawyer to sue in respect of an unpaid debt. That lawyer is too slow at pursuing those proceedings. In 2010, around 2010, our person who is owed the debt instructs a different firm of lawyers to sue the same person. And that second firm of lawyers, they get it. By 2012, they've won. The debtor, the person who owes the money, appeals, but by 2013, the appeal's disposed of. And so our client, via the 2010 proceedings, via the new firm of solicitors, has got up in his proceedings. So let me just take you through that real quick again so we ground ourselves. 2006, we instruct the first lawyer who does nothing for a few years. 2010-ish, we instruct the second lawyers. They run the proceedings, they bang over the appeal, and they get there in the end. Now, we get to the tragic part. Sadly, by 2013, our defendant, the person who's been fighting the 2010 proceedings and fighting that appeal, running that appeal, is out of money, he's bankrupt. And so our poor old client, who commenced the 2006 proceedings that went nowhere, the 2010 proceedings that went to appeal, who responded to the appeal in 2012, got up, won, has no person with any money to get payment on account of this judgment. And so we turn to our purposes today. Our client, our relevant person, our plaintiff, sues the 2006 solicitor in respect of the lost opportunity for the delay between commencing proceedings in 06 versus commencing proceedings in 2010. So that's what we're concerned with today. In short, our poor old client with the slow solicitor goes down in the district court, and we're now dealing with the appeal. And the nature of the appeal was the lost opportunity of commencing proceedings in a timely way, and running them in a timely way in 06 versus commencing proceedings and running them in a timely way in 2010, a loss in respect of which the plaintiff is entitled to damages, or in our case, the appellant is entitled to damages. And in short, 2-1, with one dissenting judge, the appeals court finds that the lost opportunity of the 06 proceedings versus the 2010 proceedings is of a type that will sound in damages in respect of the breach. Why? Right? The reason for that is that, among other things, but chiefly, by the time our defendant, our debtor, gets to 2013, when he's bankrupt, he's paid lots of legal costs in respect to the 2010 proceedings, in respect to the Court of Appeal proceedings. And it's open to the court to conclude that if the proceedings had been run in a timely way in 2006, our poor disappointed client would have won, and our person who would come to be bankrupt in the future was perhaps less likely to be bankrupt at this stage, in part because they wouldn't have incurred all the fees of the appeal and that sort of thing, in part because, you might enjoy this, the person was a solicitor at the time and so had an interest in not being a bankrupt. And so what we find is that the lost opportunity was something in respect of which damages would sound. And so the question is, how much? Well, how much is the lost opportunity? What is this time gap worth? The Court of Appeal accepted, well, any figure we come to is going to be a little bit speculative. It's going to be a little bit loose. And so they applied what might be thought of as the wisdom of Solomon. And in respect of the claim that was about $200,800, something like that, they said, well, let's say $100,000. plus costs. And as it turned out, 2-1, the Court of Appeal held that the value of the lost opportunity between the 2006 solicitor marching on in a timely way and the 2010 firm that really got things going and fought through the appeal and won in the end was speculatively $100,000. So a fiddly one today. I hope it assists you a little bit. And I hope it also gives you a bit of an insight into the first instance versus appeals process that can sometimes be a little bit mechanical, a couple of steps involved. What I'm going to do is look forward to joining you again soon for another coffee and another case note. See you.